The Act has been out there for quite a while, and I assume everybody in the audience is aware of what the Act is. Let me point out one basic thing about the design of this Act. This Act is a principles-based Act, and the rules provisions only relate to manner, procedure, etc. There are 7 principles. You must use data lawfully and use it fairly. You must use it with purpose limitation. That means only for the purpose for which you said you will take the data. You must take the minimal data necessary to achieve the purpose. You must maintain data accurately when you take decisions that affect people. And you store the data for the period that is necessary for achieving that purpose and not beyond that. And you have reasonable security safeguards. And finally, you are accountable for abiding by all this. And it actually says nothing more. The liability and the responsibility and the accountability begins and ends with the data fiduciary. The data processor is recognized. It is legally allowed so long as it is under contract. There cannot be any implicit thing like an MOU or a work order or something. There has to be a proper contract. But beyond that, should anything happen, well, you can invoke liability against the contracted party, and the contract ensures that you are able to enforce the act through that person. But the liability will end with the data fiduciary. Now, as I said, since the principles are aligned with global norms, the global practices can readily be leveraged. We don't really care whether you do it the GDPR way or you do it a different way. We are not prescribing the route through which you would achieve that. Whichever way you do it, you are responsible for securing it. The high point for all of you to consider is that you should proceed to implement the principles as sound business strategy irrespective of the rules. You shouldn't wait for any lead times. It would be a good idea to start doing so now. It begins with inventorizing. Identify all personal data held, which is simply all data by which a person is identifiable directly or in the collectivity. First of all, very basic things. Get both your applications and hosting infrastructure comprehensively audited and secured. Very often we find only the application is audited. You take the infra for granted. Won't work. Infra may be hosted wherever, but you are responsible for infra too. Every organization for separation of functions, take the trouble while creating the project proposal itself to build in the cost and provision for a separate team of cyber and information security professionals. And to have a deputy CISO for which duties have been laid out, through an NIC order in March, and use that and have a CISO and adhere to this whole regime. Define and minimize internal data access rights and do not replicate data where it is not required. And keep data always encrypted at rest and in motion. And finally, review your contracts with agencies, vendors, and monitor and audit data for compliance.